Mike Harris with What in the Law podcast. I'm going to talk a little bit about something I was doing last week, namely trial, and a little bit about what that's like and some of the things involved. First, when you go into the day of trial, you don't know 100% if your case is really going to proceed until you get to court. Emergencies happen. People get sick, and depending on your jurisdiction, especially in busy jurisdictions, there can be multiple cases set for trial in front of the same judge, last-minute plea bargains. And unfortunately, in some places, there can be this game of chicken as to who is going to show up to court and who's not going to show up. Once your case is going to proceed to trial, now you got jury selection. In Colorado Springs and many other places, you will get a written questionnaire, but that depends on where you are. Even if you do get those written questionnaires, you're only going to have a few minutes to get through them. You're going to have to be paying attention pretty quick. There's going to be a lot of questions for basically a room full of people, which is going to be narrowed down to the amount of people who are going to be on your jury, which in Colorado is 6 on misdemeanors, 12 on felonies, and for certain petty offenses or city court cases, you might have a different number like 3 or some other number. But you're not going to have a whole lot of time on this thing, so you have to be paying so much attention to everyone asking questions, including, if you're the lawyer, your turn. And asking questions and taking in that information at the same time is not an easy task. Once you finish the process of getting that jury, it's opening statements. Opening statements aren't that long, but you want to be basically giving a pretty decent explanation of what you think the case is without just reading a speech or just giving some kind of boring, keep your mind open nonsense. You want to give that jury something so they know what to look for to help your case. When that's done, it's time for witnesses. First, the prosecution goes. They call all of their witnesses one at a time, and basically goes first where the prosecution will ask what they call direct examination of their witness. When that's finished, the defense lawyer gets to do the cross-examination. Those tend to be the more difficult yes, no, try to pin them down type of questions. Then when that's finished, the prosecution will get to do a redirect examination to clean things up. Depending on your judge, there might be some more back and forth, but that's normally kind of the limits of how the questioning goes for each witness. When the prosecution is finished, there's going to be some talk about motions or requests from the defense to change something before you go on to the defense case, namely to throw out the case, which is a pretty standard thing, which is also pretty rarely granted. But on occasion, there is some legal issue that needs explanation, and even the allegations don't meet some legal requirement. But there can be other discussions. One thing that is not unusual in the middle of trial is for something new to come up that was not disclosed, or a witness to change something, and how that can affect things. Once that's finished, assuming the judge doesn't throw out the entire case, which is pretty much 99+% of the time, you go on to the defense case. Now, there are times where the defense does not put on any evidence and just stops. But normally, there's some sort of evidence that the defense is going to present, whether it be some witness to explain something, and maybe the client. That's one of the toughest decisions. Keep in mind, throughout all this, you have to keep your witnesses informed of where they need to be and when they need to be in court, because you need to have them ready when the judge is ready. And it is very difficult to predict how long someone is going to take before your witness testifies. things happen, especially when you're dealing with so many people. So you got to have witnesses basically sitting around for hours. And even witnesses who are on your side usually do not want to be there. But when it is your turn, you call your witnesses. And it's basically the same thing we talked about before, just reversing the order, where the defense will do the direct examination, the prosecution will do the cross-examination, and then the defense will do a redirect examination, and there may or may not be some other follow-up. Same thing when it's you, if you're the person on trial. Other than that, before you get to that point, the judge is going to give you a pretty good speech to make sure you are making your own decision on that. When all that is done, sometimes the prosecution comes up with some rebuttal evidence, and you do something else. Rebuttal meaning to challenge something new that has come up. There was one case in my career where I even did a surrebuttal and had someone come in to rebut the rebuttal. But that is not the normal thing, for sure. But when the evidence is finished, there may be some other discussions with the judge about motions, and then there is the important and very boring talk about jury instructions. Jury instructions can be what decides the case, especially if you are trying to argue something like self-defense or some other type of defense. To give you an idea of how contentious this can be, in the case I had trial last week, we had to take a break with an argument about whether I used the word harm or alarm when I was asking a witness a question, and whether that would change what jury instruction we were entitled to. Judge even had to go back into chambers to pull out the recording to make sure that I was right, that I used the word harm and not alarm. Thank goodness I was. But that's the type of arguments we have when we're arguing about what these words mean and what these laws mean and how confusing they can be sometimes. When you finally get those jury instructions, judge will call the jury in and read them those instructions. Now, in some jurisdictions, you'll do the closing arguments first and then read the jury instructions. But in Colorado, we read the jury instructions first, which frankly makes more sense. When that's done, closing arguments. You give your speeches about why the jury should vote in your favor. The thing that's covered the most, the biggest pressure for a lot of people, at the same time, maybe not the most important, because by the time you get to those closing arguments, the jury has already heard all of the evidence, and more often than not has an idea of how they feel about things. When that's done, that's really the hardest part, waiting, and then the verdict. So much more after that, but that's a little bit about trial and just some of the things that you got to be ready for. So, hope you enjoy, and see you next time on What in the Law podcast.